You're on the record in the Magistrates Division for the 7th Judicial District for the State of Idaho, County of Bonneville. It is 1:33 p.m. on February 13th, 2024. This is the calendar for initial appearances and arraignments. First matter on the calendar is State of Idaho versus Taylor Allen Aughenbaugh, case number CR 10-24-1447. Speaking to the jail, you are muted. Thank you. Are you Taylor Allen Aughenbaugh?
Yes, sir.
Mr. Aughenbaugh, you have been charged by criminal complaint with 2 felony counts. With count 1, aggravated battery by use of a deadly weapon. That's a violation of Idaho Code 18907(1)B. And count 2 is aggravated battery by use of a deadly weapon, violation of Idaho Code 18907(1)B. You have also been charged with an enhancement in Part 2 of the information. For each of those counts, they've alleged a deadly weapon enhancement under Idaho Code 192520 for both of them. So the maximum penalties for those offenses for count 1 and count 2 are a maximum of 15 years in prison, a $50,000 fine, and restitution. With the enhancement alleged in Part 2, the maximum penalty may be increased by a maximum of 15 years on top of that. Do you understand those penalties, Mr. Aughenbaugh?
Yes, sir.
Have you had a chance to review the criminal complaint that I was just discussing?
Yeah.
Okay. Did you read and understand it?
Yeah.
Did you have any questions about the charges that you're facing or the maximum penalties?
No.
Did you watch a video describing your rights today?
Yes.
Did you have any questions about the rights that were described to you?
No, sir.
And did you also fill out a notification of rights for a felony charge? It's a form where you initial next to the rights as they're explained to you.
Yes.
Did you have any questions about any of the rights that were described for you on that form?
No.
Okay. One of those rights is the right to counsel. Do you desire to have an attorney?
I have my lawyer.
Okay.
He should be.
Who is that?
John. I forget his last name. I just barely got to talk to him yesterday.
You don't know his last name?
No. It starts with an M.
I do see that that as of 20 minutes ago, John M. Malik has filed a notice of appearance on your behalf. So you are represented by Mr. Malik going forward. Because this is a felony offense, this is not the time and place for you to enter a plea to the charge. Instead, you will be scheduled for a preliminary hearing, which is a hearing at which the state is required to present evidence amounting to probable cause that you committed these felony offenses. At that hearing, you're entitled to be represented by an attorney, and you can challenge that evidence, or you can choose to waive that right to a preliminary hearing. If you waive or are bound over after the preliminary hearing, you'll be scheduled for arraignment before the district court. Do you understand that?
Yes, sir.
Okay. Bond has been set in this matter in the amount of $100,000. Your attorney, Mr. Malik, doesn't appear to be present. Mr. Aughenbaugh, the state is present. Mr. Neal, are you wanting to be heard with regard to bond?
No, Your Honor, we just asked that it be left undisturbed.
Mr. Aughenbaugh, you do have a right to remain silent, and anything you say can be used against you. But if you want to be heard with regard to bond, I would listen to you.
I don't have much to say. I would always request a bond reduction or a pre-trial release.
Okay. Thank you. Having considered the factors in Rule 46, C, I'm going to decline a bond reduction or release to pretrial services. Pretrial services is not recommending your release without bond. Principle in the court's mind is the nature of these offenses, which are offenses involving violence and threat to the community, and it appears that the likelihood of conviction is fairly high. So based on that information, I'm going to decline your request. We'll leave bond set at $100,000. I'm going to issue a no contact order in this matter. That no contact order will protect Aaron Murdoch, Devin Johnson, and Gabriel Perkins. There are no exceptions to that order. You're not to have contact with any of those individuals. Do you understand that?
Yes, sir.
And that order will be in effect until 11:59 p.m. on February 13th, 2027, or until further order of the court. Mr. Aughenbaugh, do you have any questions about anything that we've done today?
No, sir.
Okay, you will have a preliminary hearing before Judge Dennert on February 23rd, 2024 at 1 p.m. So please be in contact with your attorney prior to that preliminary hearing so that you can be prepared.
Okay.
Okay, any other questions or anything?
No, sir.
Okay, if there's nothing else, you can be excused. Would you state your name, please?
Gabriel Perkins.
Okay, I'll call the case. This is State of Idaho versus Gabriel Aaron Perkins, CR 10-24-1448. And you are Gabriel Aaron Perkins.
Correct.
Mr. Perkins, you have been charged by a criminal complaint of 2 felony counts. Count 1 is an aggravated battery by use of a deadly weapon. That's a violation of Idaho Code 18907-1B. You've also been charged with count 2, leaving the scene of an accident resulting in an injury or death. That's a violation of Idaho Code 188,007. Count 1 is punishable by a maximum of 15 years in prison, a $50,000 fine, and restitution. And count 2 is punishable by a maximum of 5 years in prison, a $5,000 fine, 1-year license suspension, and restitution. You've also been charged in part 2 of that complaint with a deadly weapon enhancement under Idaho Code 192520, which increases the maximum penalty of count 1 by 15 additional years.
Okay.
Mr. Perkins, do you understand those penalties as I've read them to you?
I do, Your Honor.
Have you had a chance to see the criminal complaint that I was referencing?
Which papers would it be in? Would it be in the charge summary papers?
Yeah, the document is entitled Criminal Complaint. It says charge summary on it.
Okay, yeah, I see it.
Have you had a chance to review that complaint?
Yes. Yes, I have.
Did you read and understand it?
Mm-hmm.
Did you have any questions about the charges that you're facing or the maximum penalties?
Is this the part where, I say stuff?
Well, you have the right to remain silent. So anything that you say can be used against you. The question that I'm asking you is whether you have questions about what the charges are and what the penalties are.
No, Your Honor.
Okay.
No question.
You have filled out an application for the public defender,
Yes, Your Honor.
and that application indicates that your earnings are $650 per month. Is that accurate?
A little bit. Might be a little bit over, but
Okay. Based upon that information, I am going to find that you're indigent and appoint the public defender to represent you. Did you watch a video concerning your rights?
I did, Your Honor.
And did you have questions about those rights?
Mm-mm.
And did you also fill out a notification of rights form for felony charges?
I did.
And did you have questions about the rights that were described for you there in that form?
I do not, Your Honor.
Okay. And you've exercised your right to counsel by applying for the public defender. I've appointed the public defender. Because this is a felony charge, you do not enter a plea today. Instead, we'll schedule the matter for a preliminary hearing, which is a hearing at which the state bears the burden of proving by probable cause that you committed these offenses. You will have a chance to be represented by an attorney at that hearing and challenge the evidence. Should you waive that hearing or agree that the hearing should not occur, or if you're bound over at that hearing, you would then appear before the district court for arraignment, where you would enter your not guilty or guilty plea. Do you understand that?
I do, Your Honor.
Okay. Bond has currently been set at $100,000. Would the state like to be heard with regard to bond?
Yes, Your Honor. Based on further investigation by the Idaho Falls Police Department, the state will be recommending that that bond be increased. We can proceed by proffer. There is an affidavit that is being prepared as we speak to assist the court in assessing some of the Rule 46 factors. But I'll defer to counsel if they were willing to stipulate to a proffer. At this point, I would like to have that affidavit presented to the court prior to the argument.
Mr. Crane?
Your Honor, what we would prefer, given my understanding of Mr. Perkins' situation and my anticipation of what the affidavit would contain as far as additional requests for charges, I prefer to just have the state submit the affidavit for Your Honor's review and let Your Honor make a decision regarding bond, and then should we decide to attack that decision or seek reduction or some other sort of relief, that we would do that through written motion.
Mr. Neal, your intent is to proceed by way of affidavit?
Yes, we could have that to the court within approximately half an hour. If the court was willing to wait on the Rule 46 decision until we can get that from the court.
We would need to come back and address that information for the court to make findings in open court. So in order to do that, we would have to recess on this hearing and come back. You think it's a half hour?
Walking time alone back there for a man of my extensive age takes just a little bit of time. So I think we could be very secure that it'll be done by 2:15.
What we're going to do then is we're going to take a brief recess, and we will come back on the record at 2 p.m. And if there's an affidavit at that point, then that would be preferable, otherwise we'll hear.
Okay,
Your Honor, if I might, could we ask the jail whether Mr. Perkins would be able to call the public defender's office? We'll run right over there and chat with him real quick and be back and appear before Your Honor at 2:15.
Speaking to the jail, is that something that that you can make happen?
Yes, Your Honor, I'll take him up to booking. We'll make sure he has the opportunity to call the public defender's office.
Okay, so you're saying that you want until 2:15, Mr. Neal?
that would be great.
Okay. We'll be in recess on this matter until 2:15. Mr. Perkins, do you understand what we're doing so far?
I do, Your Honor.
Okay, so you'll be taken back and have a chance to call the public defender, and then we will take up the next matter in here.
Okay.
You can be excused for now, Mr. Perkins. We'll recall State of Idaho versus Gabriel Perkins. That is case number CR10 241448. Mr. Perkins appears. Mr. Perkins, did you have a chance to speak with your attorney?
Oh, did you, Your Honor?
What's remaining is for us to take up the issue of bail. State, would you like to be heard with regard to bail?
Yes, Your Honor. You just have. And a copy has been presented to defense counsel.
I have been provided a sworn statement of Detective Rome Stifler in determining bail. I'll just take a moment to review that. I've reviewed that sworn statement of Detective Rome Stifler in determining bail. Is it your intent to file this in the case, Mr. Neal?
Yes, Your Honor. Perhaps we could just ask for that to be stamped in if that works.
We'll accept that document. Argument, Mr. Neal?
Yes, Your Honor. Based on the aggravating circumstances here that are described in the affidavit of Detective Rome Stifler, we would ask that the court increase the bail to $500,000. We anticipate that we will be amending the charge to including Alexander Barber as the victim of a second-degree murder based on a gunshot that was fired by Mr. Perkins. In this case, Mr. Perkins' conduct, both in firing the shot, which caused the death of Mr. Barber, and also the injury that was caused to Mr. Colton Clark, which is referenced in count 2. Both of these, Mr. Barber, of course, is deceased. The injury to Mr. Colton is very severe. Both of these actions show just an absolute disregard for the life of these two individuals and to the consequences of his actions. We therefore believe Mr. Perkins presents a grave danger to our community and we ask for the bond to be increased as a result.
Mr. Crane?
Thank you, Your Honor. We understand the state's request. We ask the court to consider leaving bond set as is. There's always, I think, a number of different sides to stories when something like this happens. And of course, Mr. Perkins right now isn't in a position to really express his side just because of the nature of the process. I would note that he's very young. The pretrial interview indicates a likelihood to remain arrest-free as well as appear for court. His prior record is pretty minimal. He, in his application for a public defender, I think indicated around $650 or so a month that he makes. And so I think his ability to make bail isn't necessarily something that a lot of other individuals would be able to make him much higher bail. So we asked the court just to consider those as well when making your determination about how high to raise the bond and go.
Mr. Neal, final word?
Your Honor, we just referenced also the pre-trial services report. It says the defendant reports that he does not have family ties in the area. And under employment, when interviewed by pre-trial services, he said he has been looking for work for about a week and a half. This doesn't suggest that there are strong ties to the area, and we ask that that factor be also considered by the court.
Thank you. I would note that Mr. Perkins is young, and that his criminal history is not extensive. He has a number of juvenile issues and a pending petty theft, so a fairly limited criminal history. I am in receipt of facts in the form of that affidavit of Detective Stifler indicating circumstances I think are very appropriate for the court to consider with regard to bond, including the likelihood of flight, whether or not the court could anticipate future law violations or danger to the community. The pretrial services summary doesn't recommend his release. He does not indicate that he's got a history of steady employment. I don't have much information on many of the other factors, including character and reputation, family relationships, etc. However, based upon the information that I've received, I think increasing the bond is appropriate. I will increase the bond to $300,000. Subject to review on motion and notice of hearing. Mr. Perkins, do you understand the court's order?
I do.
I'm also issuing a no contact order in this case. The individuals listed on the no contact order are Devin Johnson, Taylor Aughenbaugh, and Colton Clark. There are no exceptions to this order, and that order will be in effect until February 13th, 2027 at 11:59 p.m. or until further order of the court. You understand that I'm issuing that no contact order?
I do, Your Honor.
Okay. Do you have any questions about anything that we've done today? Mr. Neal, anything else today?
Just we're setting this for prelim, Your Honor.
I believe we already did,
February 23rd.
but that hearing will be February 23rd at 1 p.m.
Very well.
Mr. Crane, anything else today?
Not today, Your Honor, thank you.
Okay. If there's nothing else, you to be excused, Mr. Perkins.
Okay.